I will just remind you that I'm Rhonda Richardson. I'm in-house corporate counsel for HUFF, okay, and our sister companies as well. I did not write the contract. I'll start there. The Cincinnati Area Board of Realtors and the Dayton Association of Realtors revised the contract. They're the ones that have done it over the years. This is a revision. And I was told this morning that since it's been distributed, there's been a lot of feedback, and maybe they're going to look at it again. So if that happens, I guess I'll be back, and we'll and we'll talk about what changed again, right? Okay, so when we were last talking, we were talking about the inspection period. That's kind of where we left off. And I'll remind you that it kind of now has 3 timelines in it. You've got the inspection period for the buyer. You've got the written notice of defects that has to go to the seller. The seller then has a certain number of days that you're going to put in there for the consideration period, so the seller can decide what they're going to do or not going to do. The seller must respond within that period in writing. Okay, and that response can either be a counter offer saying I'll do this but not that. It could be an all-out rejection. Okay, and then there's the last period of where they try to negotiate some final agreement as to what exactly is going to happen. Okay, the main thing is to remember that these periods end with written notifications. So it's not, when the buyer's inspection period ends, they must respond one way or the other, or it's going to be accepted as an as-is purchase. So they must give some written written notice of what their defects are. And it's limited to defects too, remember? It's no longer, it can be anything but something that is considered from the home inspection report that must be attached. You've got to attach whatever thing you're identifying as a defect, basically where that came from, who identified it, what they're saying about it. Seller is not obligated to make any corrections whatsoever, so the party still can end the contract if they can't reach an agreement. Oh, and then one last thing about the inspection period. Although you've got to do all these things, there are these structural defects that they've provided for here. It's very limited, but if these exist, then the buyer can terminate. And they really are, think about them as structural defects, major defects in the foundation, lead-based paint, asbestos, structural integrity, and then hazardous materials. And if you recall what I was saying about the hazardous materials, the qualification is that it has to be a hazardous material as defined by government, either federal, state, or local, right? And the problem with that is that mold is not considered a hazardous material by federal, state, or local government. There are no standards. They're not regulating it. So if you want mold to be a defect by which you can get out, you're going to have to write that in, okay? And there's a section in the contract for special provisions that you're writing in. But keep in mind, mold is not an automatic out in this contract. You can only get out if you can demonstrate that there is a defect in the property. And then you have to substantiate that defect with a copy from the inspection report. And I'll remind you that the home inspections now do not necessarily have to be done by a licensed inspector, but if you're going to refer a home inspector, you must refer 3. My fingers up here. 3. You have to give at least 3 names. They all must have a license if you're going to identify them to your client as a home inspector. Now, they can go out and get Uncle Joe if they want, but Uncle Joe's going to have to write up an inspection report if there are defects so that they can provide those defects to the seller. If there are certain things you know that your buyer wants to be able to walk, like if they know already that they want that roof to have a life of 5 years or more, and that maybe it's only got 3, maybe the home inspector wouldn't say it's a defect, make sure that going into it, because you've got to do these things now in advance of tendering your offer, right? You're going to have to put in some contingencies that are going to expand this to cover these types of things, like mold, right? I'm saying that when you submit your offer, make sure you've got a contingency for mold, because this contract, in my opinion, is not going to cover that. If you want a certain life on your roof, make sure you put in an addendum that makes that a contingency, so that when the offer is accepted, that becomes the language that controls. Not the boilerplate here, but the exception. And then, of course, I would make sure that you're striking through that and having your buyer initial, right, so that they know that this is all part of what the offer is. Yes, sir?
Okay, having said that mold's not a hazardous material, if you have a house that's had mold, then remediated, you have to disclose.
I don't think mold is on the property condition form either, for the very same reason.
It's on the disclosure.
It isn't on the disclosure? Okay, I don't have a copy with me. So, I don't know. That's a good question. I'd have to see what it actually says about it, how it's stated. Anybody have one handy? I'm pretty sure I don't, because I didn't bring my law manual.
We can get you one.
Yeah, so we'll come back to that. What was your question?
I got one. On section D there where it says other, is that where you reference the addendum where you're gonna put things like mold in the roof?
What line are you looking at?
I'm looking at line 394.
Yeah, now I would suggest you put it in this other contingencies that's gonna come up next in line 428. So there's a place on, oh, crap, sorry. I didn't realize this had gone. If it goes out again because I forgot that it's time, please let me know, and then we'll figure it out. So what line did we say? We're gonna shoot down here to 4.
It was 393 and 94.
Okay.
So I'm saying that's where you reference the addendum that you want to get you out for a roof or mold. Not necessarily write it in there, but reference the addendum.
Yeah, so I would,
They're still not there. You got to do a little bit more.
what line number again?
394.
There you go, right there.
Other.
Yeah. So the question is, on this line 394, could you reference, it says the presence of lead-based and or other? I would probably put, because you're going to have probably several, see section 18 and then use that space in the contract where it talks about other contingencies, because it makes it very clear that this is going to be a contingency of the offer. They found it. Oh, thank you.
So in this market, with waiving inspections a lot and trying to just win a house, right? This wouldn't fly, but when the market shifts, could you just put in there under other, buyer retains the right to terminate for any reason during the inspection period?
Yeah, you could, as long as they agree to it, right? Both,
And
if
I
all the
mean,
parties
right now
agree.
that won't work, but I mean, in a year.
Right, yeah. Okay, let's see where mold is on the home inspection.
More of a balance market.
Okay, so can anybody tell me, you've got it there too?
I have it, yeah. I just had it.
Because I'm looking at presence of hazardous materials on here. It says lead-based paint, asbestos, urea formaldehyde, foam insulation, radon gas, other toxic substances.
Yeah, there's a question just for mold. You can go page 3 up at the top. It says, have you ever had the property inspected for mold by a qualified inspector, yes or no?
That's it. That's all you have to disclose. So the question about mold, simply ask, have you ever had it inspected for mold? So you have to answer that question. So if you've had an inspection, you found it, it was remediated, the question is asking, was it ever inspected? But again, you see there's no standard here for whether it is or it isn't, and it's not considered a defect.
Yeah, it's on top of page 3 on the proper disclosure.
Right,
Have you
top
ever-
of page 3.
And that's just within 5 years, according to the disclosures. And then usually we
Yeah.
just can't do anything within
Correct. Unless that's changed.
Yeah, I have to look at that because I don't, see, I think it references the statute, but it doesn't actually say the 5 years on it. Okay, so let's see where we are then. Okay, so we're gonna move on from inspection to, section 15, which is the property survey. Again, with this marked up version, everything underlined is the new part, right? And everything that's struck through is from the old. This is mainly a clarification kind of change here though, but it does tie this survey timeline into your inspection period. So if you're going to get a survey, you have to get it during that inspection period. And keep in mind that some lenders are going to want a survey, right? So whether or not this is going to impact your timelines that we went through on the financing contingencies, you've got to kind of keep all that in mind. So I'm not sure what to suggest to you about this. I guess a lot of this contract, as I said before, is going to require a lot more diligence, due diligence on your part, a lot of it in advance of writing the contract. And of course, in this hot market, you don't have a lot of time, right? So you're going to have to probably, before you even show the property, at least be able to give them lots of information about home inspectors, to have them lined up, ready to go if they decide they're going to write the contract, to talk about this survey issue. And again, I hate to keep suggesting to you that you write it in as a contingency, because I don't want to encourage you to engage in the unauthorized practice of law. But at the same time, if some of these are going to be vital to your client's ability to get out of that contract, they, make sure that they can get out, you're going to have to write them in. You can write an addendum, but it requires the agreement of both parties. So again, by the time you submit your offer, you're going to have to cover it in your offer, right? So you have to at least allow for an extension in the offer, perhaps, that if the buyer can determine that they are not able to meet the 14-day deadline for the inspection period to get the survey, the seller will allow, or they agree to allow, X number of days. Like again, you're going to have to think about all these things in advance of writing your contract. All right, so section 16, property insurance verification contingency. I think this is basically all the same, just reworded from another section of the old contract. So none of that is really new, it's just in a new place. But again, you got to think about this in terms of the timeline. 14 days. So buyer agents, guess what?
Yeah.
You can't wait again. This is not one where you're going to be able to wait till right before closing to make sure, because you've got to give the closing attorney the amount of your policy. I mean, I've been there myself. It's like, we still need you to get your insurance right. So when you're doing your sit down with your buyer client, and you're kind of counseling them about the process and the things that they're going to have to decide, make sure you're talking about these kind of things and the timeline, especially when you're going to have a large good faith deposit, right, that could be tied up for a couple of years. And of course, in this hot market, many of the deposits have been quite substantial, right? But with the change in the contract, that's going to be a lot more at risk for the buyer, because they're going to have to make sure that all I's are dotted and T's are crossed in a timely fashion, because time is of the essence in the new contract for every provision, right? Remember that, because I know some of you weren't here. So one of the new things, again, is that for every timeline, its time is of the essence, which means you must meet it or be in breach. Okie doke. Seller's cooperation.
Our buyers are now, the way I read this, not allowed in there unless we are with them.
Correct.
Is that right?
Yes. But there is the qualification at the end of that. if you can't make it, you can get the seller to send over written authorization for
That's a
the
biggie.
buyer to be on the
That's
property.
That's a biggie.
But that's still, but the seller's still going to have to send written authorization to allow the buyer on there. But if you're representing that seller and you're having your initial consultation with them, then you might want to ask them this question: how do they feel about buyers being on the property with the home inspector without their agent with them? And if they're okay with that, go ahead and have them sign something so that you can readily send that over. Now, keep in mind, this is not written authorization from the seller's agent. It doesn't say seller's agent. It says from the seller. So you need to have something signed by the seller saying that they're not trespassing, basically. If you're representing that seller and you're having your initial consultation with them, then you might want to ask them this question: how do they feel about buyers being on the property with the home inspector without their agent with them? And if they're okay with that, go ahead and have them sign something so that you can readily send that over. The buyer, according to the contract, cannot be on the property grounds without their agent unless they receive written authorization from the seller. So this seller's cooperation, that's what we were just talking about there, where you have to give the seller's express written authorization to what? Buyer acknowledgement? Yeah, to be present. Okay, so then the 18 is this little few lines that they've got in here for you to write in, you know, these small contingencies that you need to add, but keep in mind you're probably going to need to have an attachment there. So you can just check the box where it says see attachment. Okay, so title insurance. So the option here now is that the buyer does not select the owner's policy. And the owner's policy, of course, will cover them should something later be discovered after closing, right? Somebody comes and claims that they have a superior right to the property. Something's missed. Some person that maybe person that thought they should have had inherited part of the property and got left out. I don't know. It doesn't happen too often, so it's kind of hard to see when that would actually come up. But you need to think about and talk to your buyer about whether they want that. But you've got to definitely check these boxes now that the buyer does not select one. Number 2, buyer does select the policy. And if you go down to B, there's the option for the seller to pay up to $300 toward the purchase. Now, I don't know where they got $300.
It's that way now.
That's what it's always been.
Yeah.
But I mean, they all charge different, right? Yeah, so, you know, if you already know who you're going to use and the buyer has to usually select the title company, you might end up having to change that if you want them to cover the whole thing. So just keep in mind that this, as written, is only going to be up to $300. And then, or the option that pays the entire cost. So it's either up to $300, pay part of it, in other words, pay all of it, or don't get it at all. Now they struck out this section here that talks about that it's contingent on the buyer. The $300 was only if they got the owner's policy. In other words, the seller's not obligated to just throw $300 into the deal. So they struck that, but they say seller's agreement to pay any amount toward the purchase of an owner's policy shall only apply to buyer's election. So they've just kind of condensed that, made it real clear. Now this was always a very difficult one for me to try to figure out what Ohio's taxing. So all I can tell you is read what it says there and then ask the closing attorney. But you know, so basically this is about how the taxes are being prorated and trying to make sure that everybody's aware of who pays what when. And since they're billed in arrears, right, so they're a year behind, it's time to come, lots of buyers will think that should have been paid by the seller, right? And so this is to try to clarify whose obligation it is to pay. And so I think it's, at the closing table, buyer pays for the year that's coming up, right? But then they've got this, also this semi-annual period that begins after that means like half a year, right? So like I said, I don't even want to try to do the math and figure it out, but it just kind of helps to clarify for the buyer that they're going to have some tax liability that they're inheriting, basically, even though it's not for a time that they own the property. Because that's usually the thing, like, why do I have to pay it? I didn't own it during that time. But you do it because that's how you prorate, try to make it fair. The best practice advice, he said, is to never check the short proration election here, because then you're giving away the buyer's money. And I don't, like I said, I'm not real clear on that. So you all will know better based on where the contract's being written as to whether or not you want to do that. Moving on down to new construction. I don't think anything's really changed in new construction. Closing, okay. So I just kind of wanted to highlight here again where it says seller, it's line 489, seller agrees that seller is responsible for the amount of all real estate taxes assessed for the land and the residence through the date of closing, regardless of when assessed, and if one or more tax bills are issued after the additional appropriate period, prorated amount to buyer upon delivery of the new tax bill. So, but you all are probably a little familiar with that one. Nothing changed. So conveyance and closing. So they've done some cleanup here for sure. They're clarifying who's responsible for fees again, right? So the title company and/or its attorneys do not represent the buyer or the seller, and if buyer or seller desires legal representation, they should hire their attorney. This just reminds me that I always think that at your initial appointments, you need to remind them about the experts that they might need to have available to answer questions, accountants for the tax issues, lawyers for the legal issues or complicated contingency that they want to write in, or for clarification of exactly what their rights and obligations are. These are things that you're not supposed to be doing. So just keep in mind that it's not only at the closing table, which by then I think it's a little late unless you want your transaction to go south, right? So they struck the date of closing in this paragraph because they moved it down here and really expanded on this. And what they've expanded on is this is the one exception to the contract where time, although of the essence, it's automatically built in that if the closing cannot occur on the date you put in here, there is an automatic 7-day extension so long as it's not being delayed by either party, right? So maybe the lender does need a few extra days, right? Because there at the end, they've got to give all the estimates, and then that 3 days before, and then maybe something has to change, and then they got to give them an additional 3 days, kind of thing. So if there's some change in the closing date that's not the fault of either party, it automatically extends for 7 days. And possession extends for 7 days as well too. But these things come up when closing dates all the time. The difference is it's an automatic 7 days. So we're not going to argue about this, and hopefully it's only going to be 7 days and not any longer than that. If it goes longer than that, time being of the essence, right, there's a breach. Yeah, now before time became of the essence, any closing date was just a goal date. And the standard was reasonableness. Like if the delay was reasonable as opposed to intentional, right, then the reasonableness standard said that their contract's still enforceable, there's no breach. This contract, however, says that that date is a time of the essence, except that we'll automatically give you 7 if it's through no fault of either party. Of course, again, when people get upset, they're going to find fault and say, they're going to say, well, we need to go the extra 5 days. The seller's going to say, well, this is not unacceptable, and I want, because they don't think that this is So you're gonna have to be prepared to try to, keep people calm. Again, talk about this up front, both buyer side and seller side, so that maybe they can build in a contingency just in case they get to this last few days and something goes wrong and they have to expand it. They need to make sure that their movers can come, or maybe they've got a backup. I know it's very difficult to do and it causes lots of problems, but you just know that it's an automatic 7, so at least the contract's still in force. Okay, and again, as I said, possession and occupancy also gets the exact same 7 days. But you see there, highlighted in the middle, it says seller shall provide all keys, door openers, and information for items that require codes and programming no later than the time of occupancy. And that's just to make it very clear that the seller has the obligation to do that, right? I mean, I know that the agents have always said that. That's just to make sure that they see it, hopefully in the contract. It's very wordy, so they could still miss a lot of this stuff, which is why you're gonna have to make sure you're telling them. And then the provision of this shall survive closing and delivery of the deed, which means that if there are some damages there that result from some failure, that you can go ahead and close, and the parties still may have some cause of action they could bring against the other party. Now this is for you guys really, which is unfortunate. I hate to see stuff that's written in for the benefit of agents in contracts that are between 2 private parties, right? But nevertheless, think of it as just putting your clients on notice that this information will be shared, because that's basically what this is saying, is that they, both parties understand that there's an MLS and that you're authorized to share this information with other agents. Now what got me was what? Oh yeah, it says you can, seller and buyer authorize realtor to disclose financing settlement charges paid by seller and other concession data upon inquiry. Now I don't know what all can fall in. It seems very broad, number one, of what you can share about that transaction, because usually financial information is usually considered confidential, right? So be careful here, but so I'm not sure exactly where they were going with that. But then it says, and to any authorized, they struck out MLS and put any authorized database. But then it's any authorized database, but it doesn't tell me who authorizes it, right?
That's right.
So I don't know, but it's there. You should be aware of it. And of course, the goal is to make sure that the price of that house is accurately reflected. So 27, here in the next part in yellow, this contract may be executed in counterparts, each of which shall be deemed an original, but all of which taken together shall constitute one and the same instrument. Used to just say it's incorporated, that was the word, but it's now this lengthy sentence. Faxes and internet transmissions are acceptable methods of communication, but it says acceptable methods for communication for physical delivery of the contract, okay? So you can't sign the contract, well, you can sign the contract electronically, the parties can, but what this is talking about is just that you can fax or email copies. This is all that's really saying, is you can do the physical delivery to the other parties that way. Unless you're in one of the programs that allows them authentic sign and stuff like that, then you're going to have wet signatures, right? And so you can't, you can send a scanned copy of it to deliver it, wet signature that way. You could do that, but just keep in mind it has to be the property owner and the buyer's signatures on these contracts, not just the agent saying my seller will agree or my buyer will agree. That's not an agreement of the parties. That's you communicating what your party will do. Right? So make sure you have it in writing, signed. The delivery has to occur during that same period, whatever it is. So it's not going to be enough that you've dated and signed, timestamped it. They have to receive it. And that's just basic contract law, because it's not an agreement till the other party gets it, right? And you can cancel something up until the point until they actually get it. So you can sign something, send it over, and say, oh no, I'm gonna yank that back, and say, I'm rescinding that offer, or I'm rescinding that response, as long as they haven't received it yet. 28 is pretty standard, just about the general terms. Contract shall be interpreted and construed according to Ohio laws. Seller certifications and representations and warranties survive the actual closing of the property. So again, opportunity for you to dispute something long after the transaction's over. It used to be not the norm that you would do that at the time you transferred the deed, all of these things died with it. So if there were other promises, if there were repairs that never got done, that kind of thing, it would just die at the time you took legal title and control and possession of the property. But this is something under the law that's called the merger doctrine. Merger doctrine is what I just talked about. So it merges into the deed and it all goes away. And this is saying it's all going to survive. So another opportunity for a dispute long after the parties have been in the house, gone, lived there 6 months, and suddenly somebody finds something out, the contract's being litigated. This provision is basically just letting the parties know that if there is a person, a non-resident alien, that is the seller, the buyer is supposed to withhold 15% of the sales price from the seller.
It's up to the buyer to do that?
I'm so sorry.
So now we're CPAs as well, or they are.
Whoa, now this is a federal law, so it applies to housing, but it applies to all kind of transactions. But they put it in the contract so that now all the parties are aware that under this section 1445 of the Internal Revenue Code, the transferee, which is the buyer, must withhold. Now, of course, there are lots of obligations of the buyer that are performed by other people, so hopefully this is actually a closing attorney's problem.
Yeah.
My big problem with it is fair housing laws that say you can't discriminate against somebody because of their nationality, but now suddenly you've got to figure out, are you a U.S. citizen or are you a non-resident foreign alien, right? So hopefully this will be handled at the closing by the attorney, asking all parties for proof of their citizenship. Now, so you real estate professionals are going to need to make sure you remind the closing attorneys, especially if you have some suspicion that you of course have not voiced, because that would be a fair housing violation.
Yeah.
But if you have something, you might want to make sure that you've kind of said, oh, by the way, closing attorney, make sure you get proof of all of this, because it's very important, because the law also says that the transferee is liable for the 15% if it's not done. If the buyer doesn't withhold from this person that's later identified as a non-resident alien, the buyer can be held liable for the amount that should have been held back. So this paragraph 34 is just a reminder. It's written in several places throughout the contract already. There, the last sentence in yellow, that the dates and the contingencies in the contract always start the date following the date the contract is accepted. So, and this is 35, expiration and approval. The thing to pay attention to here is down at the bottom where it says buyer certifies and warrants that the signatories below have full authority to enter into this agreement, and that any and all additional signatories, i.e. spouse or otherwise, who are necessary in order to purchase the property or to obtain the financing for the real estate purchase, have expressly agreed to sign such required purchase and our financing documents, including anybody who has to give up their spousal, waive their spousal rights to the property. Again, that's, all they're saying is that they're making them certify that those people basically are on notice and they've agreed to. Many of you may have encountered this sometime where you start the transaction, the parties later tell you they're getting divorced before the closing, and then somebody gets mad and says that they're not going to do it. So just make sure that anybody who really is required to do the transfer, I'd have them sign the purchase, the offer, and if it's a seller, make sure you get all the parties to sign the actual contract. That's the best way to do it up front, is to make sure they're on. If you have a situation where it's several heirs, right? And you said, because I get this call all the time, do I have to go out and get every single one of them to sign either the listing agreement or the purchase contract? The answer is yes, but there is a workaround, which is to get them, for them to name one of their party as power of attorney, and for each of them to give their power of attorney to that person that allows them to execute a real estate purchase or transfer agreement, right? So you have to get them all to give it to one person so that you only need one person. Okay, that's pretty much it. These things here down, they changed the signature lines here to allow for, I think, a little bit more space, and to, in case it is like an entity that's doing it, whether it's an executor or executrix or an LLC member or members that have to sign. All right. So that, I think, is it. The rest of this document is more for administrative purposes. You know, so you've got someplace here that you can, if you're tendering the good faith deposit with the offer, you can already go ahead and acknowledge it. If you recall, we talked about the fact that you have to send a written notification that you've got the check in hand within, what was it, 3 days, I think it was. We go back and look at the front, at the beginning of the contract.
Yeah.
And the rest of this, I think, is
3 days
like
not specified.
Yeah,
If not specified.
yeah. So that's it. Any questions? Well, we'll see if this even holds, since there's some discussion about it. It is a lot of major changes. Major takeaway, of course, is the time of the essence clause relates to every single thing, right? So keep that in mind. Pay particular attention again to your inspection contingency stages and the written documentation that you have to provide at each of those stages within the time, right? You can't wait for the 14 days and on the 15th day send over the documentation said that it was done. You have to get that over within that period. Earnest money now is a contingency, right? So if they don't get that, then the contract's voidable. Before it was just, you know, not necessarily going to terminate the contract because you didn't receive it on that particular date. The rest of the contract would have stayed in force, but it's now a contingency. Anybody else have any good takeaways to?
Yeah, I still am like confused, like if, I'm just a kind of question, if a buyer really does want to get out of the contract, if they just go beyond those dates because time is of the essence, they're not responding back to the seller, does that give them an out to it?
No, it means they breached. So they've breached, which means the seller can then go after them for their damages, whatever those are.
I think what you'll see though is people sending full inspection reports and just saying, well, we want it all. Like what, but then the issue becomes the dispute with earnest money is going to be a much bigger problem because the seller is going to say, that's not reasonable. And the buyer is going to say, I want it all or I'm walking. And then you're going to have the earnest money situation.
Probably put down $100 and that's it. So $100 is tied up. I know in this market it's not gonna work. We're working for the buyers, the less we put down, the better off we are.
Well, that's true, but it does not mean your buyer did not breach. It does not mean that the seller cannot go after the buyer for more than the good faith, right? They can go after them for their actual damages. So if the seller had, if the buyer had offered $200,000 for the property and it has to go back on the market and they can only get $175,000, seller can go after the buyer for that $25,000. So it might have only been $1,000 they walked away from in terms of good faith, but their liabilities are great, right? So just make sure, because too many times, and I'll tell you, too many times, buyers and sellers have remorse over what they've done. I've seen sellers decide that they don't want to sell after all, and think that I'm not going to sell my house and there's nothing you can do, right? Well, there is something that they can do, and buyers are the same. They just walk. Now the problem with the buyers, they can more easily disappear. And the one thing that I notice, especially in in some of our transaction files, we don't have good contact information for the parties, right? Like if you need to have full names and addresses of the buyers, somebody you can contact in case of an emergency. That's what you tell them, right? It's really in case you need to find them because they're not responding to your phone call, right? And on the seller side, the same thing, right? The seller says, I'm going to move out of the house, or I've already moved, but I want you to list it. If you don't know where they went to, how are you going to get them some notices that you might have to in the future? So make sure you have a good mailing address for them and for the future, right? After the transaction's over even, so. Right. Yes, ma'am.
So if the time is of the essence, and I'm just using this as a terrible example, if we say that we have to have our inspection done within a week, and then our inspector can't get to it until 8 days, we ask for that, so we send an addendum and says we need 8 days instead of 7. We sign it, but the seller does not sign it. Where does that leave us? Like, we're asking for extensions on these timelines.
You have no agreement, so if you don't get it done, the inspections will be deemed waived and the buyer will have purchased as is. So if you think you might have a problem, that's why I was saying a lot of this is before you make your offer, you're going to have to do a lot of homework and due diligence, making sure that you can get your inspectors there. In other words, somebody's going to make an offer. You've got 3 inspectors, your buyer has said, I want to use this one. Somebody's contacted them before you write that offer, says, yeah, they can get there within this 14 days that we're going to put in here, right? Now, it doesn't mean that they will. People, things happen. And you maybe have to have a backup ready to go in case, but at least you'll know that you've talked to somebody who can get out there.
So, what happens a lot, if the furnace in here maybe is 12 years old, then the home inspector will say they recommend getting an HVAC technician to inspect this almost every time. And if the roof is maybe 15 years old, they do the same thing, recommend. So sometimes it takes a week to get this, or 10 days to get someone out.
Then I would put it in as a contingency in your contract that if the inspection comes back recommending that some other licensed professional provide additional inspection of that unit or whatever it is, that the inspection period will be extended. It's getting rough to be a real estate agent. Yes, you will, because you will have no agreement to go beyond the 14 days or 10 days, whatever you've allotted for the inspection. If you don't get it done, the contract says that the buyer has basically waived the inspection and they're taking the property as is.
And if you have an inspector who, based on the age of a furnace, is calling for an additional inspector, you need a new inspector. Because you already have it, you shouldn't. You already paid this guy to give an opinion. Give me the opinion, is it defective or is it good? You don't need, why do you hire an inspector to get other inspectors? That's almost like being honest.
Yep, all they're doing is passing the buck.
That's it. I know, but you need to find one who doesn't.
And again, that's what I was saying. You work with the inspector to make sure that they're documenting it the way you need it, right? Now, maybe defective is not going to be sufficient for this contract. The only thing that they can ask for repairs on is something that is defective, right?
So maybe the answer is a pre-listing inspection.
Well, that'd be on the seller side.
Yeah,
right?
but if you're selling your house, you're gonna list it, maybe you should revert to a pre-listing inspection.
Age is not a defect. So if he's calling for an additional inspection
Right, I
based
agree,
on
yeah,
age,
I agree.
it's out of
I know, I agree.
Right.
I agree on the furnace and that,
But you can build in some additional time. Like I said, you can build in as part of a contingency that if further inspection is needed because of something that the inspector only could identify. You could write that in as needing another inspector, a licensed HVAC contractor. Then you'll get an additional 7 days or additional 3 days or whatever.
But the age of furnace, again, going back, is not considered a defect.
That's correct. So what the home inspector has to say is that they highly recommend that another contractor, specialist, come in to determine this blank, whatever that is that's wrong or they think might be wrong. And then you will have had to have written in your offer already that the buyer has an option to extend the inspection period to get those additional reports. I mean, that's just one way in terms of a best practice that you can build in some time without your buyer having to lose out or take it as is automatically, because that's what this is. It has to be a defect in order for them to even ask for repairs, right?
Or reduction in price.
But if it's working,
Or reduction.
it doesn't matter how old it is.
No, it does not.
Buyer's agents have never done this is a defect and this is, maybe in the future will be a defect. It's a defect now or it's not a defect.
That's exactly right.
It says future defects don't apply.
That's
And
exactly
another
right.
reason
Right.
You're supposed to show up at your inspections to explain this to the buyer and to the inspector. That, okay, that's a future defect, it's not a defect. So either phrase it properly or move on.
Right.
And again, like I said, if you think that this is going to be an issue or you want to make sure you're covered, buy your buyer a little bit more time by writing it into the offer.
And a listing
That-
agent can still counsel their listers, clients, to cross that out and say, I'm not gonna
Absolutely.
accept that.
Any provision of the contract
Yeah.
though. Any provision, I mean, when they sign the contract, they're saying they agree to everything. So if there's something that they're not agreeing to, they're supposed to counter, right? Or put the strikeout, which basically represents a counter to what you received. So if the buyer sends it over with paragraph 8 intact and seller sends it back with paragraph 8 all marked out, that's a counter offer. And there's no agreement. It's only after you finally get an agreement where both parties are signing. So build it in, like I said, in advance because you want your seller to see the offer and accept it right away. You don't want a counter, right? That's the way you get the property, is that you make the best offer you can, the seller accepts it without having to say, no, I'm not going to do this, just to be able to start negotiating. In this market, that's what you want. Now, the market one day will turn back and it will be more of a buyer's market one day, right? And then you won't have to worry about doing so much of this in advance, and you'll probably get a whole lot more concessions out of your seller. But right now, because of the competition that's out there, you've got to make sure that that first offer you make has everything in it that your buyer needs to protect them, but still is acceptable to your seller. But you can't forget the things that you need so that your buyer can get out if needed.
Okay, real quick question. Some of these agents are writing backup offers. I offer 300 and get it accepted. Somebody writes backup at 325. We do the inspection. The seller wants it to go down. So what do we do in that case to protect our buyers?
Watch the dates.
Ask for nothing on our inspection so they can't get out?
I mean, in today's market, buyers are doing a lot of crazy things. They're waiving inspections, they're waiving appraisals, right? They're going thousands and thousands of dollars above asking price. They're throwing in trips to Walt Disney World, right?
Yeah.
Baked cookies for a year. I mean, it's kind of crazy. So,
And if you found something and you know there's a backup offer that's greater than yours, the inspection was for informational purposes only.
But we
Okay,
don't
so
know that there's a backup until they.
Well, the seller doesn't automatically have the right to terminate though at that point. They could just say no, just like they can right now. And the
Exactly.
buyer can either take it or leave it,
exactly.
right?
yes, from the inspections, yeah, absolutely. If you send over a list of defects, the seller can simply say, no, I'm not doing any. Then goes back to the buyer. Say that's acceptable or it's not.
And that's the
That's
difference.
terminated.
That's a difference.
That's the difference between.
That's not terminated, it goes back and they can say, well, if we can't reach an agreement, then it's terminated.
That's why there are 3 periods now,
Right.
the inspection, the settlement, or the consideration,
And
then the settlement.
yeah.
So that gives your buyer the opportunity to say, I'll just take it as is.
Well, good luck. If there are changes and you'd like me to come back to this so we can talk about them again, I'm happy to do that, okay? So thank you guys for coming.
Thank you.
Uh-huh.